Madam Speaker, the Legislative Council, having this day agreed with amendments to a bill entitled A Bill for an Act to amend the Adoption Act 1988, the Anti-Discrimination Act 1998, the Births, Deaths and Marriages Registration Act 1999, the Civil Liability Act 2002, the Conveyancing and Law of Property Act 1884, the Criminal Code Act 1924 and the Status of Children Act 1974, now returns the same to the House of Assembly and requests its concurrence therein. J.S. Wilkinson, President, Legislative Council, 9 April 2019.
Thank you. Leader of the House.
Madam Speaker, I move that the last mentioned message be taken into consideration tomorrow.
Madam Speaker.
Thank you.
I move that the last mentioned message be debated forthwith.
Well, hang on. Seek to amend.
So that's you seek to amend it?
Amend the motion.
Right, okay. So you seek to amend the motion.
Seek to amend the motion by deleting all of the words after the word debated and replacing them with the word forthwith.
Thank you.
There isn't the word debated in it.
Madam Speaker, on the amendment.
The Honourable Leader of the Greens on the amendment.
There is no word debated.
Madam Speaker, we rise to support the amendment as put by my colleague, the member for Clark, the Shadow Attorney General, and move that this debate on the amended legislation be dealt with by Parliament forthwith. Madam Speaker, and it is extremely important that this House recognises it has a responsibility to deal with this amended legislation today. This legislation has been rigorously examined by both houses of the Tasmanian Parliament, and a majority of members in both houses of Tasmania's Parliament have agreed that the Births, Deaths and Marriages Amendment Bill, as it is in this House today, should be passed. And it should be passed today, Madam Speaker, because every day we delay on dealing with this legislation is a day that potentially causes harm to transgender people, and that is a fact that's recognised by a majority of members in both houses of the Tasmanian Parliament. Now, we sought yesterday to have the Premier provide some clarity to transgender Tasmanians about when this legislation would be debated. He refused to do so. There is no justification for not dealing with this legislation today, and if the Premier gets up and says, we want this to be delayed because we need the Tasmanian Law Reform Institute to have a look at it, I just point the Premier to the Law Reform Institute's statement, which is very, very clear, Madam Speaker. They cannot and will not examine this issue under the terms of reference until the legislation is enacted. Now, if people on the government side of the House are concerned, then they should be very keen to see this legislation enacted so that the Tasmanian Law Reform Institute can examine it, Madam Speaker. But this House has a responsibility here today to deal with this amendment bill. And I'm just going to put some statistics out there, Madam Speaker, to focus people's minds on why it is so important. The American College of Paediatrics, Madam Speaker, has undertaken a study on the risk of suicide and self-harm for transgender people. And it found for transgender men, 50% reported transgender teens having attempted suicide in their teens. For transgender women, the statistics sit at around 30% of transgender women attempting suicide or self-harm in their teens. And when you look at the stats for non-transgender people, for women it sits at 17.8% and for men under 10%. This is a fact that we need to deal with, Madam Speaker. Delaying debate on this legislation is harmful. It has been months now, months. And we've had the kind of language coming out of organisations like Women Speak Tasmania, the alleged Coalition for Kids, seeking to throw in red herrings, stall debate on this legislation so that they can whip up fear and loathing in our community. Now, if the Premier gets up and talks about the Attorney General's concerns relating to the Solicitor General's advice, Solicitor General's advice that she waived privilege on but will not make public. And that Solicitor General's advice was clearly made in the absence of knowledge about the amendments that the Upper House delivered that dealt with those concerns, Madam Speaker. All the concerns that the Attorney-General has raised as part of an extremely damaging and hysterical response to this amendment bill have been dealt with by the upper house in the amendments. Now, if people are concerned about the legislation that left this place, I urge them to read in detail the upper house's amendments. It's important to understand, Madam Speaker, those amendments were drafted by the Office of Parliamentary Counsel. Now, at this stage, this Parliament does not have access to the Office of Parliamentary Counsel, and we delivered those amendments in this place in good faith. But it is hard to argue, if you have concerns about the robust of the legislation, that the upper house hasn't made significant improvements to the language of the amendments. Now, you know, some of us will have concerns with some of the amendments potentially, but it is a robust bill, Madam Speaker. And once it is enacted, transgender Tasmanians will have the right under law to be who they are. And small L Liberals on the government side should hang their heads in shame.
That's right. Absolutely.
This is core small L Liberal policy. Individual rights, individual human rights. The right of people just to be who they are. Madam Speaker, Madam Speaker, the House must deal with this legislation today. It must deal with it forthwith, and it is on that basis that we support the Shadow Attorney-General's amendment.
Thank you. The Shadow Attorney.
You didn't speak to your own motion.
Thank you, Madam Speaker. I'm speaking to the amendment.
Speak to your own motion.
I'm sorry, Attorney General, you missed that jump. No, you had to speak to it at that time. Right. Anyone else wish to speak to this motion?
Right, Madam Speaker.
Leader of the House.
Well, Madam Speaker, this is really obvious what's happening here this morning, and I'd have to say that the leaping to her feet by the Shadow Attorney on this matter is an improper use of this House. It is not appropriate. I would like to be heard. It is not
It is my understanding that Standing Order 224 does allow for this.
Madam Speaker, I seek only to be heard. The government asserts this is not a proper use of this House at all. The amendment message has only just been received and it is extensive. Just look at it. The detail, it shows the work that the Legislative Council members saw fit to do to fix the mess, that was made by members. It shows the effort that's been gone to fix the mess that was created by members opposite, and that is what you were warned about. Now, the simple. If I could simply allow, if you could listen to a different perspective, please. The attorney is not present today, and members opposite ought to reflect on that. This is the Attorney-General's bill. It's got her name on it. It's important that she be here for its consideration of its amendments. And members opposite... Look, isn't it interesting how people won't allow others to be heard, Madam Speaker? Now, the fact is that yesterday the opposition did everything it could to prevent these messages being received yesterday. That was very clear. And the government does have important legislation to deal with this week. We started debate yesterday on our nation-leading PTSD legislation, and we're keen to see it transmitted to the other place this week. And we are seeing, with the extensive, with the extensive range of amendments, the government needs time to look at the amendments that have been put through, to consider them, which is why, and it speaks perfectly to the reason that this House should not be hastily ramming these amendments through without proper advice, without proper consideration. We have said, the attorney has said, it is important that the TLRI inform this House before it rams through these amendments.
Have a point of order, Minister.
The Leader of Government Business is in denial of the reality that the TLRI cannot and will not look at this issue until the legislation is
Not a
enacted.
point of order, that's a debating point. Now, Madam Speaker, I think it's improper
Don't mislead
that
the
members
House
want to...
that the Law Reform
I'm
Institute
sorry.
will reflect on the bill.
I don't
worry.
believe that's a point of order, but that is
point
my
worth making.
understanding as well.
Yeah, but that is a debating point. At the moment,
It's not,
I'm
it's a
articulating
fact.
a reason why you're wrong about what you're asserting. Now, we say that this is unseemly haste, it's an improper use of the House. While the standing orders may well allow this to occur, every Tasmanian will know that Labor and the Greens today intend to ram these changes through our parliament regardless of the impact that it will have on the Tasmanian
Been
community.
months
The
and
attorney
months
has
and
been
months of
quite
debate.
clear.
There's no
This is a
ramming
dog's
through.
breakfast. It has got problems at law. The attorney has indicated
Really?
to Legislative Council members that she has advice from our Solicitor General that indicates significant,
How big
deep
is
problems
that
with
Not
these,
with the upper house's
Labor
amendments.
Green amendments.
The Solicitor
And
General
so,
did not comment on the
while
upper
there's no
house's
denying the
amendments.
significance in this issue, that should be a reason
just complete-
to not rush it
Paying
through
all
this
the
House.
advice.
And I think it's very clear, in
Privilege
the
has
absence
been
of the
waived.
attorney today, who nobody will argue for her reasons being unable to be here today, this should not be rammed through this House
It won't
on
be
the
rammed
power
through.
of numbers by Labor and the
Debate all
Greens
day.
in full knowledge, in full knowledge that there are deep problems with the Labor Green amendments. Even the ones that have been fixed up, there are still problems.
Those
You've been
amendments.
told that,
There
and be it
hasn't
on
been
your head,
comment on those
we've indicated that
and they were released
if
a
Labor and the
month
Greens
before
combine
debate.
and ram this legislation through today, you're doing so knowing that there are deep problems with this
There are not.
legislation,
Rubbish.
and it's a creation of
Rubbish.
your
The
own making.
Solicitor General's
About
advice.
politics.
Thank you, Mr O'Byrne.
Madam Speaker, the member that just resumed his seat started his contribution by saying it's obvious what is happening here. Yes. Well, I think it is very obvious what is happening here. It's been obvious for the last 6 to 9 months what is happening here. You are promoting hate in our community. You are promoting division in our community. You are promoting misinformation and intolerance. And you have used, talk about the improper use of the House and the forms of the House. You have used every trick. Well, there's a couple of other words that spring to mind. You've used every attempt to deny the will of both houses to see this bill work through the processes, to have it debated, to have it amended, to have it considered, and then to have it go through to the finalisation of the parliamentary process. You have used every trick inside this House, and you have, through your press conferences, through your media releases, through your contributions on some radio stations, you have promoted misinformation, division, disunity in this community, and you should hang your head in shame. This is obvious what's going on here. We know what's going on here, and it's absolutely disgraceful. Now, initially you said it was not within the standing orders. Well, it's very clear it's within the standing orders of 224 to deal with this. Now, both houses have debated this matter at length. The committee process upstairs and the briefings, the amendments, the hours long of debate in the upper house have worked through the issues that you say have been raised and are a cause of a fatal flaw within the legislation. Those matters have been resolved. Those matters have been considered in the upper house, and it is disrespectful of this House, the process of this House, and the extensive work that the upper house did.
What are you saying to the independents
and if you had
in the
any
upper
heart,
house?
if you had any heart to listen to the contributions of members of our community and the members of the upper house who are not aligned with the Labor Party, the genuine independent members of the upper house, the heartfelt contributions, heartfelt, in trying to resolve what is a scar and is a wound in our community, moving amendments to resolve this matter that will not impact one iota a whole range of members in our community, but for a number of key members of our community, it will resolve a significant issue. If you had a heart, I would ask the member who just resumed his seat to go back and have a read and look into your heart. Look into your heart.
Read the amendment.
You regularly claim this a Christian belief system. We also hold this as well. We also hold this as well. I'm asking you to look into your heart. to look into your heart.
You've made a mess of it.
Now,
Absolute opposite of what
now,
he just
Madam
did.
Speaker.
Order.
Now, Madam Speaker, I didn't hear that. I'm not. It's a belief system. And it's about caring. It's about loving, and it's about reducing people's
I don't care
trauma.
about that. Respect
And
for
this
others.
debate,
That's not a Christian value, respecting others.
is crucial. It's to the heart of people in our community and how they can conduct and have their lives free of discrimination, free of intimidation, and make some decisions. I'm a grub, am I? I take offence to that. I take offence to that, Madam
I do
Speaker.
take offence on your behalf. Thank you.
Now, Madam Speaker, both House... Pardon?
I say it's very grubby.
Oh, Madam Speaker, that is
withdraw
disingenuous.
it, and I would ask the Honourable Minister to refrain from that kind of commentary.
Madam Speaker, this matter does need to be debated forthwith. It's a matter that's been considered by both Houses of Parliament, extensively debated in both Houses of Parliament. It is important to those that are impacted by this legislation that this House deal with it today to resolve it and then set us on a path where we can remove a significant issue for some members of our community. And I seek you to consider these arguments and to allow us to finalise the debate on this matter.
Thank you. Thank you. Ms Woodruff from Franklin.
Madam Speaker, I think the case has been amply made for urgency on dealing with this bill. It has been something that the Liberals, the Minister has done everything possible to push aside, to degrade the people who have spent years, more than a decade, trying to make this incredibly tiny change that will mean absolutely...
I take a point.
The attorney, that is absolutely unparliamentary, making such an allegation.
It's a statement of fact.
The attorney has never been in that position, expected and expressed that view, and I'd ask her to withdraw that allegation, which is defamatory.
I don't believe that's a point of order, and I'm going to let Ms Woodruff proceed.
Well, thank you, Madam Speaker, because I didn't make any allegation. I just stated the facts. This minister has done everything she can to hold back the tide of respect and recognition that this bill will bring in. This is a bill which has been fought for by people who will have every impact on their daily life, every impact on the life of their children and the life of their loved ones. I mean, just listen to the statistics Ms O'Connor said. Look into your own hearts and imagine why 50% of trans men commit suicide, attempt to commit suicide. That is just the most appalling figure. Look into our hearts. How can we stand here after Christchurch, the condolence motions that we made, the conversations that we've had in this place since then about language, about the incredible importance of leadership of all people in Parliament, to bring people together, to heal wounds, to reach across divisions. Instead of opening them even further for short-term aims, think about how we can build our community, build a stronger Tasmania, a community where people share difference, respect difference, where people feel part of a community and included, rather than pilloried, denigrated, made to feel different, made to have operations they don't want to have, in order to just simply be able to say who they are and to be legally recognised for that. This is a bill which must be dealt with today because people's lives have been held up for years, for decades, and every single day matters so much to them. This is something which is totally the business of Parliament. It has been given so much attention by members angsting over words and the details for months now, and the Office of Parliamentary Counsel have done absolutely everything to find the words that will satisfy members of both places. So here it is before us today. It is our job, it is our duty to dispatch this debate today and get it done.
Thank you.
No leader of the opposition.
There being no other speakers. The question is that the amendment be agreed to. All of those that opinion say aye. Aye. Those to the contrary, no.
No.
I believe the ayes have it.
Divide, please.
Divide. Division, please. Ring the bells. You're happy? Happy? Okay. So we'll close the doors, lock the doors and stop the bells. So the question is that the amendment be agreed to and the House will now divide. The ayes will pass to the right of the chair and the noes to the left. I appoint the honourable member... Yeah. I appoint the honourable member Dr Broad teller for the ayes. Dr Broad. And I appoint the honourable Mr Shelton teller for the noes. Thank you. Well, I don't think there'll be too many surprises here. The result of the division is 11 ayes and 11 noes. So the result leaves me in accordance with Standing Order number 167 with the casting vote, and in order to give this legislation the most rigorous debate, I cast my vote with the ayes. Again. So therefore, the question is that the motion as amended be agreed to. All of those opinions say aye. Aye. Those to the contrary, no. No. The ayes have it. Goodness. Okay, the division is required. Ring the bells. Just do this. Shown. Right, the whip's happy. Then please stop the ringing of the bells and lock the doors. The question is that, sorry, was it the bill as amended? The motion as amended is before the House, so the House will divide. The ayes will pass to the right of the chairs and the noes to the left. I will appoint the Honourable Mr Shelton for the noes, add the Honourable Dr Broad for the ayes. You're welcome. Thank you. The result of the division is 11 for the ayes, 11 for the noes, and in accordance with Standing Order 167, I cast my vote with the ayes.
Honourable Premier. Can we just read the amendment? Does the committee wish to handle it as a group or individually?
No, we'd intend to take each amendment separately. Be considered individually. Thank you.
Amendment of the Legislative Council to Clause 1.
Premier.
Thank you, Mr Chair. And I'll make some comments broadly with respect to the legislation that's before us now, and avoid, I would hope, the need to be repetitive on each and every clause other than with respect to specific provisions and the government's view in relation to those. But it is appropriate for me to inform the House at this point again of our opposition to this legislation, which we do consider to be flawed in its operation, its impact on other statutes, It's not, in our view, undergone adequate consultation nor indeed with the community, and the fact that the Legislative Council has completely changed the bill that was introduced by Labor and the Greens and which they've wanted to have this Parliament pass swiftly shows how badly it was drafted in the first instance without
Giving us access to parliamentary counsel.
Full legal review. We do consider it to be a subversion of good lawmaking, and that is an important responsibility for any government to ensure that the laws that pass through this place are good, and to not have legislation rushed through into the Legislative Council. And what we now have is a complete rewrite of that initial body of legislation. It is entirely unrecognisable from what was first before this House. So we will be voting against the bill, as we did in the House of Assembly last year and in the Legislative Council last week. Our position is and remains so that these matters should go through full legal review before being passed by Parliament. That's why we've referred the matter to the Tasmanian Law Reform Institute.
You can't look at it until it's enacted.
Miss O'Connor, officially warn you for the first time for constantly interjecting. That's 3 times you've interjected on the Premier.
And I do just want to bring to the members' attention a statement from the Tasmanian Law Reform Institute in relation to the reforms before us and the reference before them. And it says very clearly, and I quote, "Preliminary work on this reference has commenced and will continue regardless of the status of the Justice and Related Marriage Amendment Bill 2018. So, Madam Speaker...
Keep reading.
Well, I'll read the whole thing out. This means that the work of the TLRI should not defer consideration of the bill by the Legislative Council. Our research will incorporate consideration of the terms of any bill passed into law. I mean, it goes on.
So they won't consider
Madam
it
Speaker, Mr Chair,
that's what it says.
The Law Reform Institute, regardless, is perfectly placed, in our view, to provide that full legal review that is being expected of this Parliament and being proposed by members of this House be rushed through. And as we've said, Madam Speaker, in contravention of legal advice that we have received as well, and which has been the subject of this debate, and which is not to be dismissed lightly, Madam Speaker. So despite legal stakeholders, including the Solicitor General, the President of the Tasmanian Bar Association, for example, raising serious concerns and pointing out there's been no opportunity to undertake a full review of what's being proposed and how it impacts on other statutes. It is, in our view, entirely negligent, irresponsible for Labor and the Greens to seek to enact a bill that may cause legal uncertainty for Tasmanians. And the fact that the term gender is not included in the short title of the bill demonstrates how far outside the scope both the House of Assembly and proposed Legislative Council amendments are. I do acknowledge the efforts of the Legislative Council to try and fix clauses inserted by Labor and the Greens into the bill, but the government certainly doesn't support the inclusion of the clauses in this bill, certainly not the government's original bill. And given the lack of consideration by Labor and the Greens to the legal ramifications, which are significant, of the current legislation, it's highly likely, in my view, that the Parliament will need to reconsider and likely fix up problems with the legislation at a later date. And we'll take further advice as to that. Certainly will not rule out repealing the Labor-Green amendments in part or in full. It would be irresponsible of any government not to look at the effects of these amendments. So, Mr Chair, I move that amendment to Clause 1 not be agreed to.
Thank you very much. Honourable Shadow Attorney General.
Thank you, Mr Chair. Labor will be supporting this first amendment as presented to the House from the Upper House. And I would reflect on some of the comments that the Premier made in his opening remarks. First of all, he said the original bill was badly drafted, the original amendments in this place were badly drafted and there had been no consultation. That's simply not the case, Mr Chair. There has been extensive consultation over many years and decades on these issues. There was a report in 2016 that garnered several community consultation submissions. The amendments themselves were brought to the government by advocates in the community months before they were brought to opposition parties. There was a lengthy debate in the lower house, Mr Chair, and in the upper house, and there has been excruciatingly long, for some people, public debate ever since then, with every single member of parliament receiving multiple representations from members of our communities on their views, very varied that they are, on the amendments proposed here in the lower house and the amendments proposed in the upper house. It's interesting, Mr Chairman, that the Premier indicated that he appreciated the work of the upper house, and certainly the Leader of Government Business in the upper house said the same last week. I sat through that debate in their chamber, and she commended the independent members of the upper house for their power of work with the access to Office of Parliamentary Counsel to, in the government's words, fix the amendments that were passed in this place, Mr Chairman. Whether that's how you characterise the work of the upper house or not, they did a power of work, Mr Deputy Speaker, Mr Chair. They did a power of work that should be recognised and appreciated in this place. Mr Chairman, the changes that the upper house made make this a piece of legislation that will protect the rights of transgender people. It makes simple, very simple changes, and there has been such an enormous scare campaign, Mr Chairman, that the government has not only done nothing to dampen, but they have fuelled the flames of that scare campaign, Mr Chairman, across Tasmania. Even this week, Mr Chairman, members of the government have misrepresented the changes made in the upper house. They have absolutely misrepresented details of the bill that was debated as it was in the upper house, Mr Deputy Speaker. And as for consultation, the Law Reform Institute does have a reference in front of them, that's true, and the Premier selectively read from that letter that has been an unprecedented step, I might add, that the Law Reform Commission said that they don't usually release terms of reference and speak about references before they commence that work. But what they go on to say that the Premier conveniently didn't read into the Hansard is that in accordance with the law reform practice, they will not comment on bills before Parliament or any related amendments. That means they will not comment on the Justice and Related Marriage Amendment Bill 2018 or any related amendments until a final form of the bill is enacted, Mr Chairman. So that's what the Law Reform Institute said.
The next paragraph.
That's what they said. The preliminary work on the reference has commenced and will continue regardless of the status, but their research will not continue until there is a bill passed into law. This means the work of the Law Reform Institute should not defer the consideration of the bill by the Legislative Council. Our research will incorporate consideration on the terms of the bill when passed into law. That's right. With respect through you, Chairman. So they may have a reference in front of them, but they are prevented and will not be making... It's a furphy for the government to say that this legislation and these amendments can wait until they've received a report in September from the Law Reform Institute, because that report, Mr Deputy Speaker, will not be completed until a bill is enacted into law. And that's the next step for these amendments, Mr Chair.
Mr Chair.
Member for Denison, Ms O'Connor.
Mr Chair, we're debating the first amendment, which alters the short title of the bill to reflect the inclusion of matters relating to gender, and of course we support this amendment. I just wanted to challenge something that the Premier said in his contribution. It's quite clear to me that the Premier is not across the amendments and the changes that were made to the amendments by the upper house. And he has also demonstrated total disrespect for upper house members and, of course, but we're used to it, Labor and the Greens members in this place, by accusing upper house members of subverting good legislative process. Well, that's what you said. A subversion of good lawmaking was exactly...
Labor and the Greens.
Well, you can try that. You can try that,
Labor
Premier,
and the
but
Greens.
you are...
Yes, I do
You're in denial.
Through the chair, please.
Greens members
Order.
upstairs, if there are any.
Well, regrettably, there are no Greens members upstairs, and I remind you of the vote, Premier. The vote, Premier, was 8 for the amendments, 6 against the amendments. There are 4 Labor members upstairs.
Right, that's not the numbers.
And that is irrelevant. A majority of members in the upper house,
that as a compliment.
having thoroughly examined and tested the amendments, having met with Office of Parliamentary Counsel at a meeting which I understand they were told they couldn't take notes at, but a majority of members of the upper house have backed in these amendments after a full summer of examining the bill that we sent upstairs. Now, that is not a subversion of good lawmaking. That, Chair, is good lawmaking. And the Premier says that his government wants proper process and expert advice. Well, Chair, the advice, the summary of the Solicitor General's concerns was only given to upper house members a day before debate on the bill was due to start. Now, Chair, that's not good process, that's an ambush. And we have seen this from the Attorney-General, we have seen it from other government members. You can read it in the debate in the other place. Constant subversion of the facts. Constant willingness to play politics with this issue, regardless of the human collateral damage, Chair. So, Chair, of course, we will support this amendment, and we'll support every amendment that the upper house has delivered to this place. Those amendments reflect the will of this house, yet they have been through Parliamentary Counsel. This is robustly drafted, tested and passed legislation in the upper house, Chair. And our concern remains that we just heard a threat from the Premier to potentially repeal this legislation. You people need to get over the fact that you are not in control of this House. You don't own this Parliament. It is the will of the Parliament that we reform the Births, Deaths and Marriages Act, the Anti-Discrimination Act and those other parcels of legislation in the manner that is in the legislation before us today, the amendment bill. So, Premier, I'm sure that you would rather not be sitting there defending your government's odious position on this legislation. I feel that you are uncomfortable. I am certain that you are not across the amendments. I'm certain of it because of the contribution that you just made. And if you want us to take you seriously on legal concerns, table the Solicitor General's advice. Privilege has already been waived on that advice.
Yep.
And let's remember, of course, that that advice, which was dumped on the Legislative Council the day before the debate was due to start, was advice that was given before the Legislative Council had debated the amendments.
It wasn't given on the Legislative Council's amendments at all.
That's
there were
right.
Concerns with the original amendments.
Thank you, Ms Haddad. So that advice, it needs to be understood, Chair, is outdated. It's a redundant piece of advice, but it would be good for the House to see it, seeing as government members and the Premier keep referring to it. If you're going to waive privilege, table the advice.
Right.
Otherwise, what you're putting on the table here is a big, fat, stinking red herring. And really, Premier, you should be ashamed of the comments that have come out of the Attorney-General throughout the course of this debate. The willingness to throw up furphies, to give voice to those awful organisations like Women Speak Tasmania and the alleged Coalition for Kids. Awful.
You've just called them out as awful. These
Awful.
Tasmanian people.
I stand by that. I stand by that. I could have said a lot worse. I could have told you what I really think of them, Mr. Ferguson, but I chose not to. Well, What worries me, Mr Ferguson, is that when members of our transgender community read the kind of garbage that your Attorney-General put out on government media release letterhead, it hurts them. When organisations like Women Speak Tasmania, who clearly do not understand transgender issues, put the kind of rubbish out that they are, it hurts people. When self-appointed experts who call themselves the Coalition for Kids, and yet it turns out that the lead spokesperson's from the Catholic Church. When they come out and lecture us on the well-being of children, frankly, I want to vomit. So, Chair, we will be supporting this amendment. We will be supporting every amendment that the upper house has delivered to this place. And we know that when today is over and the law has changed, people who've been stigmatised and discriminated against under Tasmanian law since forever will breathe out and breathe a sigh of relief. And they will know that a majority of members in both houses of the Tasmanian Parliament support their right to be who they are under the law, not to face obstacles in the law. And part of the reason that this debate has become so difficult, Chair, is because in fact, Tasmanian law really doesn't recognise transgender people other than the Anti-Discrimination Act of 1998.
Laura.
That's part of the reason this has become so complicated.
The Chair will...
Right, and that is a challenge for lawmakers.
The motion
But it starts here and it starts today.
The question is that the amendment be disagreed to. All those of that opinion say aye.
Aye.
Well, can we seek some clarification, Chair?
No. Because
No.
just point of clarification.
The question is that the amendment be disagreed to.
That's the motion.
That's the motion that was put. So all those of that opinion say aye.
Aye.
To the contrary, no. The ayes have it.
clearly had it.
Divide.
Division required. Division required. And it might take a few for a start. Whip's happy? Happy? Whip's happy? Whip's happy? Okay. Is the pair. I haven't called for separation. There is a pair in place though. There is. Are the whips happy? 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 Stop the bells, lock the doors. The question is that the amendment be disagreed. Those of the... it be disagreed to. The ayes will pass to the right of the chair, the noes to the left. I appoint teller for the ayes, Mr Tucker, and teller for the noes, Dr Broad. Joan. Is there a pair in place?
Thanks for that. Thank you.
Thank you. The results of the division: ayes 11, noes 12. Therefore, the noes have it. Second clause. Second clause.
Amendment of the Legislative Council to clause 2.
Premier.
Mr Chair, I move that the second amendment to clause 2 be agreed to. We're supporting this based on advice provided by the registrar that at least 4 months is required for systems upgrades.
Honourable Member, Ms O'Connor.
Thank you, Chair. This is the second amendment, which inserts a new clause A to replace the clause to enable time for the transition arrangements required by the registrar to be facilitated. This is an improvement to the legislation and acknowledges that it will take some time for the transition to be in place with the registrar. I need to understand what the Premier just said then. Is there new advice from the registrar that this is not enough time, Chair, because we certainly haven't been privy to that advice. I don't believe it was made available to the upper house, Chair, so we will be supporting this amendment as delivered to this place by the Legislative Council.
Ms Haddad.
Thank you, Mr Chair. Is that how I address you, Mr Chair?
You're just Chair. Just Chair, sir.
Labor supported this amendment in the upper house and will be supporting it here. It was an amendment moved by the Honourable Member for Murchison, Ruth Forrest, which allows for a later commencement date for amendments to be dealt with later.
The question is that the amendment be agreed to. All those of that opinion say aye. To the contrary, no. The ayes have it.
First amendment of the Legislative Council to Clause 6.
Premier.
Thank you, Chair. I can advise that with respect to the first amendment to Clause 6, the Government, as we did in the Legislative Council, would support it, as we will indeed to the second and to the seventh. Sorry? Well, yes, we will. I'm just dealing with them individually. Is that the Chair's wish?
We're working through them individually.
Yes, so the First Amendment, Clause 6, be agreed to.
Ms Haddad.
This was an amendment moved by the Honourable Member for Launceston, and it's an example, Mr Chair, of some of the community consultation that has been undertaken on this bill by every Member of Parliament, as I mentioned earlier. So many Members of Parliament would have received correspondence from members of our electorates who were concerned with the government's move, Mr Chair, in the original bill as dealt with in this place, which were to leave out the words to make legislation gender neutral. I acknowledge that it's parliamentary drafting practice spreading around the world that legislation should, where possible, be gender neutral, Mr Chair, and I agree with that premise. Labor, I don't believe, I think we did support this in the upper house in recognition, Mr Chair, that this has been one of the concerns raised by members of the community, albeit that I agree that legislation where possible should be gender neutral. I think it's an opportunity for us to reflect on the fact that not just this, but the bulk of the amendments that were moved by the upper house were done so after considerable consideration of the bill and the amendments moved downstairs and community consultation, Mr Chair. Thank you.
Ms O'Connor, Member for Clark.
To save time, agree with the contribution made by Ms Haddad. The reason that the Premier is comfortable in supporting this amendment is because it's a significant improvement on the amendment that the government had included in the original bill, and that is that it leaves out the words a parent or guardian, and it inserts the words the mother, the father, the mother, or parent or guardian. And this should allay some fears in the community about a perception that Parliament was trying to do away with motherhood and fatherhood, just as we're dealing with a false perception that Parliament is trying to eradicate gender. This is a substantially improved amendment that's come down after rigorous testing in the upper house along with the other amendments.
Question is that the amendment be agreed to. All those of that opinion say aye.
Aye.
Contrary, no. The ayes have it.
Second amendment of the Legislative Council to Clause 6.
Premier.
Thank you, Chair, and I move that the second amendment to Clause 6 be agreed to.
Question is that the amendment be agreed to. All those of that opinion say aye.
Aye.
The contrary, no. The ayes have it.
Amendment of the Legislative Council to Clause 7.
Premier.
Thank you, Chair. I move the amendment to Clause 7 be agreed to.
Question is that the amendment be agreed to. All those of that opinion say aye.
Aye.
The contrary, no. The ayes have it.
First amendment of the Legislative Council to Clause 13.
Premier.
Thank you, Chair. I move that the first amendment to Clause 13 be not agreed to.
Why?
I'll take the opportunity. The government remains concerned that the definition of gender declaration only requires a person to identify what gender they personally identify as at the time of the declaration. It does not require any intention to permanently live as the changed gender, and there are no limits on the number of times that a person can change gender.
Mr Chair.
Honourable Member for Clark, Mr Dad.
Mr Chair, Labor will be supporting this amendment. And my gosh, I hope that the Premier's tongue stuck in his mouth a little when saying those things just now.
Yes.
I'm a little lost for words, which doesn't happen to me very often. What these amendments do, and I'll reiterate what I said about the power of work done by members of the upper house. This amendment was moved by the member for Murchison. It was respected in the upper house by the Leader of Government Business there as having significantly improved on the attempts downstairs. And the member for Clark has outlined the fact that because we don't have access to the Office of Parliamentary Counsel in the lower house, the intent of those amendments that we met in the lower house are still being met by the amendments in the bulk moved by the member for Murchison. Mr Deputy Chair, I don't know what kind of world the Premier is imagining that we might live in and that transgender people might live in. Right now, the requirements for somebody to have the simple change made on their birth certificate to have their gender marker changed from one to another, not on the Register of Births, Deaths and Marriages, not on government records, all of that information would continue to be kept and recorded. But simply the piece of paper that you walk away from Service Tasmania with, to have that reflect the true gender that you are, right now there are onerous requirements for those people to go through in our legislation. Be divorced if married, and have invasive, life-altering, dangerous, often unneeded and unwanted surgery. Yep. I spoke about that on the second reading contribution when we debated these last year. I am abhorred that anyone would think that a bunch of politicians should have the say in whether somebody undergoes invasive physical surgery. If I were to undergo invasive physical surgery of any kind, with respect to all of you colleagues here, it wouldn't be you that I'd be coming to ask for advice on about that, or checking the statute books, or permission, or checking the statute books about what surgery I might require. I'd be talking to my doctor about that, Chair, and I'd be talking to medical professionals and to my family and loved ones about such a thing. The Premier said words along the lines of the government's not supporting this amendment from the upper house because it doesn't, I don't want to misquote you, Premier, but something along the lines of it doesn't require people to intend to live as the other gender. How would somebody demonstrate that to your satisfaction? Yeah. I'm not wearing a skirt today. Does that mean that I don't intend to live as the gender that I express myself as? How would somebody meet that bar, intend to live?
And what business?
And as for changing willy-nilly, one, that's offensive to imagine that anybody would be so calculating as to day on day go and change their gender on their birth certificates. For what purpose? To prove some kind of bizarre bureaucratic point. And I will draw members' attention to the fact that there is an amendment that would outlaw that practice to be considered later in this package of amendments. It was moved by the member for Windermere, Mr Dean. If accepted, and I hope the government will accept Mr Dean's amendment when we come to it later in this package of amendments, and that would allay the fears in the community that any such behaviour could be entered into by a transgender person or anybody else in the community, Mr Chair, and in fact would not be able to, as the Premier expressed that there might be some concern from government members that people would change willy-nilly their gender day on day. That in fact would not be possible if the bulk of these amendments, and particularly that one from the member for Windermere, is accepted. Thank you.
Chair.
Honourable Member for Clark.
Thank you, Chair. Well, look, I'm glad I asked the Premier to clarify why He doesn't want this amendment to be agreed to because it did actually expose a fair bit, unfortunately, for the Premier and his alleged Liberal values. Premier, you are feeding into the myth and the narrative that transgender people will treat transitioning and being their true identity as trivial, that this will be something that people want to do once a week, just because transitioning is so much fun. Not. Chair, the concern I have, Chair, is that the Premier, I don't think, has spoken to enough transgender people about their lived experience of claiming their identity, being respected for their identity, and the lived experience of coming up against the barriers in law to having their true identity recognised, not only by the law but by society more widely. There is, Madam Chair, Mr. Chair, there is just nothing fun or enjoyable or easy about transitioning for a transgender person. And this is the clause in the legislation, Chair, that does deal with, in part, the requirement for a transgender person to undergo really invasive surgery before they can have their birth certificate changed. And I resist in this place talking about personal issues, but I'll just talk about my kid for a minute. Jasper, at the moment, like Jasper's Jasper, and Jasper's a 20-year-old young man, but every single official document he has misnames him. His bank account, his tax file number, his student card. Every time he and other transgender people who can't get their birth certificate changed because of the sexual reassignment provision go to apply for jobs or any other element of officialdom where you need formal identity documents, they have to out themselves. My child's name is not Mara. And every bit of official documentation lies about my child's name. And the law right now says to my child, you have to have a hysterectomy before we recognise who you are. Well, that's garbage. Now we need to fix this. We support the amendment.
The question is the amendment be disagreed to. All those of that opinion say aye. Aye. To the contrary, no.
No. Clearly the noes have it.
On the voices, the noes have it.
Correct.
Division required.
Mr. Ferguson, are you thinking this through?
Whip's happy? Whip's happy? Stop the bells, lock the doors. The question is the amendment be disagreed. The ayes will pass to the right of the chair, the noes to the left. I appoint Mr Tucker, teller for the ayes, and Mr Bacon, teller for the noes. Thank you. Thank you. The result of the division, ayes 11, noes 12, therefore the noes have it.
Second amendment of the Legislative Council to clause 13.
Chair, I move a second amendment to clause 13 be not agreed to.
Question is that the clause be disagreed. The question is that the amendment of the Legislative Council be disagreed to. All those of that opinion say aye.
Aye.
The contrary, no. No. On the voices, the noes have it.
Right.
Division required. Ring the bells. Yeah, take a bit of get used to it, just the back way, back to front way of doing it. Thank you. Whips happy? No? No. Happy? Happy? Whips happy? Okay. Stop the bells, lock the doors. The question is that the amendment be disagreed to. The ayes will pass to the right of the chair, the noes to the left. I'll appoint Mr Tucker, teller for the ayes, and Mr Bacon, teller for the noes. Right. He must have had an itchy neck. He was you.
Thank you.
The results of the division, ayes 11, noes 12. Therefore, the noes have it.
Legislative Council amendment to clause 14.
Premier.
Thank you, Chair. I move that the amendment to clause 1 be agreed to.
Question is...
Yeah.
To leave out the clause. You agreed to leave out.
Yeah. It's not now, Bill. We agree.
So the question is that the amendment be agreed to. All those of that opinion say aye. To the contrary, no. The ayes have it.
Legislative Council amendment to clause 15.
Premier.
Thank you, Chair. I move that amendment to clause 15 be not agreed to.
Honourable Member for Clark, Mrs Add.
Thank you, Chair. Sorry. Thank you, Chair. Speaking on the change that the Legislative Council made to clause 15, which is to leave out the word gender and instead insert the word sex into proposed clause 15 as debated by the Upper House. It makes sense, Chair, for my comments to relate to this clause change and also to the previous one just agreed by the Chamber to leave out clause 14. What these two changes do is deal with how births are notified by hospitals and at the time of birth. The reason that it's important to point out some of the reasons that the member for Murchison moved these two amendments is that they go to the very heart of some of the scare campaign that has been allowed to play out in Tasmania and indeed around the country over the last several months. Part of that scare campaign that we heard from several organisations and the embers of which were stoked constantly by members of the government was that we were erasing gender from Tasmania, Mr Chair. I'm pretty sure everybody else has heard those claims in the community or has read newspaper articles by extreme conservative journalists who have claimed that what the attempted amendments in the lower house did were effectively to remove gender from Tasmania. How ludicrous, how absolutely ludicrous that scare campaign was, Chair. And it was really hard for me as a new politician to hear. But you know who it was a lot harder for is the transgender and gender diverse people in Tasmania and around Australia who are thinking, why is this Parliament choosing to play games with our lives, Mr Chair? Why is the Tasmanian Parliament the Tasmanian community choosing to play games with what is actually a really extremely serious health issue for transgender and gender diverse people, Mr Chair? So what these two changes moved in the Upper House do, the removal of clause 14 and the amendment to clause 15, will make it extremely clear that upon notification, upon birth, there are two things that happen within quick succession. One is the hospital must notify the government that a baby has been born. That has to happen, thanks to the amendment from the Upper House, within 21 days. So that's the current law and that will stay as it is. Within 21 days for a live birth and within 48 hours of a stillbirth. The hospital must notify the government that a child has been born, and they must notify the government whether that child is male or female. No other options available to the hospital, no other availability for the hospital other than to notify the government that a live birth within 21 days or a stillborn baby within 48 hours, a baby has been born, either male or female, Mr Chair. So that the hospital will continue to have to make that notification to the government within 21 days. And the amendment to section 15 recognises that at birth, Mr Chair, it is sex that's being registered by the government. It's notified by the hospital, a live birth has occurred, the baby was a boy, put that on the register please, and that's what will occur. It is sex that is registered at birth. And that goes to the heart of why the remainder of these changes are so important today. That it is sex that is noticed at birth. To put it crudely, as the member for Murchison explained in her experience as a midwife, basically we have a look between the legs and say, this one's a girl, this one's a boy. That's what will be notified by the hospital to government, and that's what will be registered and recorded and kept in government records, Mr Chair. Gender, on the other hand, is something that might be wrong, might not be correlate with what is noticed at birth and what is put onto the register. Gender is much more complicated than that. And there are not just two genders, Mr Chair. And that's why the remainder of the changes in this package of amendments from the Upper House that will go on to debate are so important to recognise the fact that when somebody's sex assigned at birth doesn't correlate to the gender that they later seek to live, that the law in Tasmania will protect them from discrimination, protect them from the kinds of administrative pain that we've heard the member for Clark explain, of having a series of documents that simply don't reflect who you are. Thank you, Mr Chair.
Question is, Honourable Member for Clark, Ms O'Connor.
Chair, of course, we will be prepared to support this amendment, which changes gender to sex, as it's the sex of the baby that's recorded at birth. And I just thought, for the benefit of perhaps the Premier and some of his colleagues who don't understand the distinction between sex and gender, our office has put together some information I'm happy to share with the Premier, but I'll put some of it on the record now. Chair, there is a distinction between sex and gender. If there were not, there'd be no need for two distinct words. It is important to remember that both sex and gender are human-defined terms, and while they may have a basis in observable traits, it doesn't mean that either are naturally defined terms. A mismatch between apparent sex and how a person identifies is a real phenomenon. It's a very strong drive causing gender dysphoria in some, a condition that's recognised by all significant psychological bodies. It's not simply a vague feeling, and of course there is also some debate over even the use of the term dysphoria, because dysphoria medicalises a fact, and dysphoria points to, it seems to indicate that there's something wrong with that person, and that's not the case, Mr Deputy Speaker. Mr Chair, institutions like the Australian Psychological Society and medical publications like the Diagnostic and Statistical Manual of Mental Disorders base their position on research and evidence, not activism. The idea that these organisations are incorrect about the distinction between sex and gender is not supported by evidence. In fact, the only basis for the idea that gender and sex are not different comes from an individual's own strong belief that they're not different, which is ironically the exact notion opponents are trying to discredit as meaningless. So, Chair, this is a significant change. It should allay some of the fears that were expressed in quite hysterical terms by the Attorney-General and others within the community about the gathering of statistical data that relates to births in Tasmania. This is a straightforward amendment. I do hope that the government, the Premier, doesn't call a division on it. There shouldn't be an argument about this particular clause, Chair.
The question is the amendment be disagreed to. All those of that opinion say aye. Aye. To the contrary, no. No. I think the ayes have it. On the voices. On the voices. Division required. Ring the bells.
Including.
How many was the count? Whip's happy? Whip's happy. Stop the bells, lock the door. The question is the amendment be disagreed to. The ayes will pass to the right of the chair, the noes to the left. I call Mr Tucker teller for the ayes and Mr O'Byrne teller for the noes. Thank you, Mr O'Byrne. Ten, 12. Thank you, Mr O'Byrne. The results of the division, ayes 10, noes 12, therefore the noes have it.
Legislative Council amendment to clause 16.
Premier.
Thank you, Chair. I move that the amendment to clause 16 be not agreed to.
Question is, Ms Haddad, member for Clark.
I'm genuinely asking this question. There's no politicking here, but I would like to know the Premier's reasons. And I hope he'll outline them for not supporting this change. This one was moved by the member for Murchison. It was actually a pretty hard one to swallow in some ways, but we're supporting it here. What this amendment does is actually makes the recording of sex mandatory by the Registrar of Births, Deaths and Marriages. The current legislation is silent on whether the Registrar must record that information. Currently, under the Tasmanian legislation as it stands right now, the only thing that the Registrar is required to record is a name, Mr Chair. But this amendment actually, and as I said, there was a lot of discussion around this debate in the community and in the Parliament, and the member for Murchison did a lot of work, but in particular on this very clause that we're debating right now, she did an enormous amount of work consulting on this, and it wasn't an easy process for her. There was a lot of unease in some parts about this change. So what this now does, this change, if accepted, is to make it a requirement by law that the Registrar of Births, Deaths and Marriages will record sex on the register, and will keep that information on the register. Right now it is recorded and kept by government in a range of different ways, but this will actually, for the first time in Tasmania's history, and there are several other jurisdictions that don't make it a legal requirement that sex is recorded at birth. But this will change under this amendment, Mr Chair. So I am genuinely interested in the Premier's views on that, and I say that in good faith, that I would like to know the Premier's reasons, and I hope that they're heartfelt ones about why it would be better for the registrar not to record sex on the register. Thank you.
Thank you, Chair. Certainly, this is another example of something that was certainly not in the government's original bill, for a start. Certainly also not a matter that has been, in our view, properly considered. The advice that we've received is that this clause does remove the power for a person to change their sex and allows only for a person to change their gender. So as a result of this clause, if an individual has sexual reassignment surgery, they will not be able to change their sex.
Don't.
Ms O'Connor.
Sorry, I'm having trouble believing right now that you are concerned about the rights of transgender people to change their identity documents, given the palaver on this bill. Chair, this amendment replaces the existing amendment that was set upstairs that allows information about sex or gender to be collected under Section 50 by the registrar, with amendments that require the registrar to register the sex of the baby as either male or female. I share Ms Haddad's relative discomfort about boxing human beings into that binary construct, but acknowledge that this is a mandatory provision that will require the registrar of births, deaths and marriages to register a person's sex as either male or female at birth. Now, Chair, I just thought also this clause ensures the registrar has the statutory power to correct errors made in determining the sex of the baby and prevents future changes of registered sex, instead allowing the amendments in Clause 21. It also enables the subsequent registration of a gender or of a change of gender. Any registered change of sex made before this bill comes into effect remains valid as the registered sex of the person. Now, Mr Deputy Speaker, I just wanted to continue briefly some education materials, information for the Premier on the difference between sex and gender. And the reason that I express a concern about the registrar recording sex as male or female is that there's a whole lot of medical evidence out there that it is much more complicated than that, Mr Deputy Speaker, but we believe this is an improvement on the current situations and we're looking at this in the context of the bill in its entirety. Now, Mr Chair, whether a person has a penis or a vagina is not the sole factor in sex. Genitalia are primary sex characteristics, characteristics presenting at birth, and characteristics such as breasts in female are secondary sex characteristics which develop during puberty. This has been a long-standing conceptualisation of sex characteristics. We're not conceived with an immutable blueprint of our adult form. Genes guide our development, most of which is enacted at various stages between conception and the end of puberty. At 6 weeks, in utero, the gonads in a fetus become either ovaries or testes, which will secrete either oestrogen or testosterone, typically causing one of the potential sex organs to wither away and the other to develop. A lot can happen, Chair, both before, during and after this development, which can lead to inconsistent or unexpected presentations of sex characteristics. And Chair, we know that people can be born intersex, that is, neither clearly male nor female. Sex is not so much determined at conception, Chair, but rather by a range of characteristics, some of which are developed in the womb, some of which develop during puberty. Sex chromosomes are not an absolute measure of sex. they're one factor that guides development of sex characteristics. Chair, based on available data, about 1 in 100 people develop in a way that presents observable physical characteristics that are contrary to what would be expected from their primary sex chromosome. And I say primary sex chromosome because not all people have only one sex chromosome. In fact, microchimerism means that it is unlikely that any males are completely devoid of female sex chromosomes, and Chair, this number could be higher as many people go through life unaware of these variations. For example, a womb was discovered in a father of 4 children, which was only discovered at the age of 70 when he was undergoing a hernia operation. Chair, human beings are complicated and miraculous. People who the law currently doesn't adequately, in fact barely recognises in Tasmania, their unique, miraculous being must be recognised by the law, and their rights to that identity, that individual identity, must be recognised and protected, and that is what Parliament is seeking to do today for transgender and gender diverse people.
The question is, Honourable Member for Franklin.
I just also wanted to encourage the Premier to provide a bit more background to Parliament about what the reasons are for not supporting this particular amendment. I don't think that I understand the basis for why you wouldn't agree with this amendment, because it's actually, from where I sit, a lot harder to support this amendment from my point of view, because we have come to a place of understanding through working on this bill about the complexity of human existence. And I think what this has challenged me is to look past the statistics and abnormalities and to stop treating this as an academic exercise about this kind of chromosomes and genetics and hormones, and understand that for all of those different categories of obscure and wonderful variation in human existence, there is an individual life behind that statistic. And the individual life that we're talking about, that we care about, is an individual Tasmanian life. And those people, Ms O'Connor quoted a statistic of about 1 in 100 people who are believed to be born with variations such that they would be neither male nor female in the strict term that we've come to understand that definition. Another statistic I've heard is that it's actually more like 1 in 52. 1 in 52, as I understand, is about as common as redheads are. So if we reflect on that and think about the fact that the more we understand, because of science, because of genetics, because of all the tests that are available, DNA testing, we have access to information we've never had as humans, as a human race. And really, a lot of the research in this area has been done by around the Olympics. It's been done around elite sport, where a huge amount of money and research has gone into determining this very, very question. How can you tell if a person is a male or a female? Which box do we let them fit into for elite athlete sport? Which box do we allow them to fit into so that they can stand on the podium and be the best javelin thrower, best woman javelin thrower, or the best male javelin thrower? And what we've come to understand, to the surprise, probably the sorrow and the grief of many of those individual people, is that they have travelled through their life fitting into being put into a box, only to be have revealed to them by the Olympic Committee or some other body that they're not actually who they thought they were. The case I heard yesterday was of an Indian woman who comes from a poor village in India, and through dint of her own tenacity and strength of character, made it to the Olympics, only to find through some testing regime that she has a particular chromosomal difference, so that she's not technically, according to where the Olympics have got to on this very complicated issue, considered to be a woman. What a shocking thing to come to terms with in that environment. But really, this bill is not about all of that stuff. That's academic stuff. This here is actually about people's lives, and for the people that this bill will make a difference for, it's not an academic issue. They know that they don't fit into the binary box. They know. Either they've known it from the very day that they have memories, and we hear stories. There's been beautiful documentaries done, Australian and overseas documentaries about children who knew well before their parents, before they were able to talk to their parents, they just didn't fit in their skin. And then they grew up and they were able to take control of their life and make a decision for themselves. This is core. This is about recognition. Recognition from your parents, recognition from your school, from your community, that you are who you feel you are.
Who you know.
And so we can go through chromosomal testing and genetic testing and hormonal testing, but really what it comes down to is where a person is in themselves in their life, and their right to be recognised as who they know they are. And it is our job to pass this bill today, pass it as efficiently and expeditiously as possible.
Hear, hear.
Because it will make so much difference to the lives of Tasmanians. So I would really encourage the Premier to think again about, or to really make a strong statement so that we can understand why you wouldn't support the amendments that are being made in the upper house, and this is one of them.
Hear, hear.
Question is that the amendment be disagreed to. All those of that opinion say aye. Aye. To the contrary, no. No. The noes have it. Division required. Whips happy. Whips happy. Stop the bells, lock the doors. The question is the amendment be disagreed. The ayes will pass to the right of the chair, the noes to the left. I'll appoint Mr Tucker teller for the ayes and Miss Butler teller for the noes. Flick you.
you.
Thank you. Thank you very much. The result of the division, ayes 10, noes 12. Therefore, the noes have it.
Legislative Council amendment to clause 18.
Premier.
Thank you, Chair. I move that the amendment to clause 18 be not agreed to. This lowers the age at which a person can independently apply to change their name from 18 years or older to 16 years or older. It's certainly not the government's position in the original bill. Both the bill and these amendments lower the age at which a person can make that application. This is inconsistent with the law in other areas similarly, and indeed in relation to major decisions that one might make. It's inconsistent with laws in other jurisdictions and has the potential to cause issues for existing data matching rules. So on that basis, we do not support the conclusion of the clause in the bill.
Briefly, Chair.
Honourable Member for Clark.
This amendment is a refinement of the language that was in the amendment that went from the House of Assembly to the Legislative Council. In fact, it's grammatically better. And I just point out to the Premier that young people at the age of 16 are in a very good position to know who they are. It is Greens policy that young people, 16-year-olds, if they wish to, should be given the vote, Chair. So it is, it's extremely disappointing to hear the Premier suggest that 16-year-old transgender and gender diverse people shouldn't have the right to have their true gender reflected on their birth certificate, and that they should have to go through unnecessary hoops in order to have that happen. So we strongly support not only this amendment but the following one, which is consequential and almost identical.
Clark, Mr. David.
I'll stay put for either time as well. There was a really quite heart-wrenching debate in the upper house on this amendment, where we heard some really eloquently put personal stories from transgender and gender diverse Tasmanians about their lives and about their experiences, Mr. Chair, of coming to that realisation that something wasn't quite right for themselves. And it's long before 16, Mr. Chair, it's long before 16. And the idea that somebody would have to wait until adulthood to have their identity documents simply reprinted with information that reflects their true gender is really quite cruel, really cruel, Mr. Chair. And for that reason, we supported this change in the upper. Actually, we introduced this change in the lower house. What the upper house amendment does is makes the language more consistent with Tasmanian parliamentary drafting styles. That's right. And as we've heard a few times, we don't have access to Office of Parliamentary Counsel. So through the IPC, the member for Murchison corrected that language. We had the language of 16 years or over, and she's amended that to read who has attained the age of 16 years. So in effect, this amendment itself is just a simple one, changing language. The next one also does the same, Mr. Chair, and for that reason, we'll be supporting it.
We were about to call, weren't we?
I've concluded my contribution on that amendment. Thank you.
Where are we? Clause 20?
No.
Clause 18. We haven't, and I was about to call it if nobody else wished to speak. The question is that the clause, that the amendment be disagreed to. All those that opinion say aye. Aye. The contrary, no. No. The noes have it. Division required. Ring the bells. Well, not lock the doors yet, no. It wasn't on my desk, wasn't it? Thank you.
Thank you.
Whip's happy? Yes? Have you got one? One's out? Oh. Ah, right, okay. Whips are happy. Lock the doors, stop the bells. The question is the amendment be disagreed to. The ayes will pass to the right of the chair, the noes to the left. I'll appoint Mr Tucker teller for the ayes and Miss Butler teller for the noes. For the ayes, teller for the noes. The results of the division, ayes 10, noes 12, therefore the noes have it. Next clause.
Amendment of the Legislative Council to Clause 19.
Thank you, Chair. For the reasons articulated with respect to the last clause, I move that amendment to Clause 19 be not agreed to.
The question is that the clause be disagreed to. All those that opinion say aye. Aye. To the contrary, no. No. The noes have it. Division required. Ring the bells. Whip's happy? Whip's happy? All right. Stop the bells, lock the doors. The question is that the amendment be disagreed to. All the ayes will pass to the right of the chair, the noes to the left. I'll appoint Mr Tucker teller for the ayes and Ms Butler for, again, teller for the noes. Thank you. Thank you. Happy? The results of the division, ayes 10, noes 12, therefore the noes have it.
Amendment of the Legislative Council to Clause 20.
Premier.
Thank you, Chair. I move that amendment to Clause 20 be agreed to.
The question is that the amendment be agreed to. All those that opinion say aye. Aye. The contrary, no. The ayes have it.
Amendment of the Legislative Council to Clause 21.
Premier.
Chair, I move that amendment to Clause 21 not be agreed to. This is an entirely new part of the Act. The government has consistently made the point that the amendments have not been properly considered or consulted and presented a range of practical problems with them. The fact that there have been dozens of amendments and an entirely new part in this place demonstrates that is correct. It's clear there are uncertainties that still exist in the bill. As the Solicitor General has said in his briefing to the Legislative Council, there are very real legal consequences, and while the amendments proposed seek to fix the problems, we need to be mindful that there were examples identified by the Solicitor General in his preliminary view. New section 28B also removes the best interests test, so a magistrate no longer needs to be satisfied that it's in the child's best interests in order to approve the registration of a child's gender. This potentially allows one parent to change the gender of their child without the need to consider at all what is in the child's interests or the view of the other parent. The Commissioner for Children and Young People wrote in a letter to all members of the Legislative Council on the 19th of March 2019 that Article 3, Paragraph 1 of the Convention on the Rights of the Child gives the child the right to have his or her best interests assessed and taken into account as a primary consideration in all actions and decisions that concern them. The Commissioner has suggested that a best interests test should apply where there is an application to a magistrate to register a change of gender. Chair, this was again not in the government's original bill, and the government does not support its inclusion via this clause of the bill.
Member for Clark, Mr. Haddad.
Thank you, Chair. The Premier's right. This does, on paper, represent a new part of the Act, but in actual fact, most of the way that the lower house approached the changes that needed to happen to Part 4A of the Births, Deaths and Marriages Act last year, when the original amendments were considered in this place, it was logical to, in essence, rewrite that section of the Act as an amendment. But in actual fact, most of what exists right now in Part 4A of the Births, Deaths and Marriages Act was replicated in the words of that amendment. I won't go back over what the Premier said about this being unconsulted or not well considered and that there are uncertainties remaining. I don't agree with those statements. There's been months and months of public consideration and public consultation on these changes. But there is one part that I feel I need to respond to in what the Premier said, which is that the Solicitor General expressed concerns. We know that the Attorney has waived privilege in regards to the Solicitor General's advice, but has not released his advice. I would ask the Premier his views on whether or not he would release that advice. But my understanding is that that advice was given on the basis of the bill that was presented to the Upper House. Yep. So the advice was not given on the amendments that the member for Murchison and others had drafted, and indeed the concerns that he raised, many of them were dealt with in those amendments that were moved by the independent members in the Upper House. I find it extraordinary that the government would go to such lengths as they are going to now to alienate those members of the Upper House who worked so hard on, in the government's words, fixing the amendments that were attempted in the lower house. These have been done in good faith, and they've been done to retain the essence of what was attempted in the lower house and to achieve it in a way that represents good law, Mr. Chair. From my memory, one of the issues that the Solicitor General raised as a concern was that changes represented in the bill and in the amendments may cause problems for police conducting searches on transgender and gender diverse people. The member for Murchison followed that up quite rigorously with the Commissioner of Police, who explained that they already have policies and procedures in place for when searches are required on people who are transgender or gender diverse or non-binary, that kind of thing. Notwithstanding that, the point that I want to make here is that the fact that those problems might occur is not a reason not to support the reforms that we're changing and suggesting here. It's a demonstration of the fact that there are problems with those policies and those behaviours of public service agencies who don't have legislation or policies in place that deal with the fact that there are transgender people in our community, and there are transgender people and gender diverse in our community who interact with every part of our community: education, health, justice, police and so on. So I think that that advice from the Solicitor General should motivate the government to in fact improve other areas of the law.
Yes.
That don't treat people the way that they should expect to be treated by their state, Mr. Chair. And what this change does, this amendment from the Upper House, is to actually articulate the fact that we're removing the current test, if you like, of how somebody is to have their gender marker changed on their birth certificate, which at the moment is divorce and surgery. So if you remove the existing processes, they must be replaced with something else, and these changes replace them with a new process for how somebody would go about having their gender marker changed on their printed birth certificate and identity documents. But despite that, and despite the Upper House members giving every impression that they understood the intent of those changes, they understood the differences that the member for Murchison's changes represented as compared to what was passed in the lower house, senior members of the government, Mr. Chair, have continued to bandy about things that are completely ill-informed and wrong. Mr Chair, and I'll give an example of a radio interview that was given last week by a very senior member of the government. She was asked, under these changes, will parents who now have the option of putting a sex on a birth certificate of their child be able to put a sex that's demonstrably not the biological sex of the child? The answer to that question should have been to the radio interviewer, no, that won't be possible under these changes, because all children at birth will be registered male or female, Mr Chair. But that's not what the senior member of the government said. She said it's hard to say at the minute because it's not finished yet. He said, so you don't know the answer to that question? Because I thought that's pretty obvious. If you have the opportunity as a parent to make these sorts of judgments, you look at your little girl and you go, oh, well, we want to call him Jack, we'll put him down as a boy. Is that possible? The answer to that question should have been, no, that's not possible under these changes. It's not possible under existing law, and it won't be possible if these changes pass. But her answer to that question was, at the moment, that's a very real possibility. Shame. That's heartbreaking to know. Like, I want to do a good job in this place, but how do you combat that when someone's willing to just say something that's completely a distortion of everything that they've just heard in weeks and months of consultation and writing amendments and debating amendments and speaking to one another? I don't have the words for it, Mr Chair. I wish I did. But it is hard to come up against people who will just do and say whatever is required to make something go away, regardless of the veracity of those claims, and I was really disappointed to hear that interview. But we will be supporting this change. It's a very well written and very thorough new piece of legislation that will replace the current requirements and laws regarding how gender changes are dealt with under Tasmanian law. Thank you, Mr Chair.
Chair.
Member for Clark, Mr. Connell.
Thank you, Chair. Look, I am just going to stay in my seat to indicate that we strongly support the legislation, the amendment as it's come back from the other place. This clause is in fact for transgender and gender diverse people the substantive part of the reforms and the legislation, and it will deliver a fairer, non-discriminatory process for people who need to change their gender identity in order to have documents that reflect who they are. And I just wanted to, first of all, pay my respect to Ms Haddad for the thoroughness with which she is approaching this legislation, and that contribution that she just made then, which said it better than anyone else in this place could have said it. Premier, stop insulting the upper house. They rigorously debated this section of the legislation that we're looking at today. It was over a number of days, Chair, and weeks indeed, but the debate itself over a number of days. And just to point out to the Premier, this legislation is about the best interests of the child at its core. Yep. Chair, it's about the best interests of transgender and gender diverse and intersex children, Chair. And I would argue that we should approach it in this way, that it is about children, and simply point out again to the Premier that the way his Attorney-General has dealt with this issue, and Ms Haddad didn't name the other member, but it was the Leader of Government Business in the upper house running the Attorney-General's talking points, who's running the talking points of Women Speak and the Coalition for Kids. And in fact, when media, as I understand it, went to ask the Attorney-General for comment on the births, deaths and marriages amendments, often there was a suggestion that journalists go and talk to Women Speak Tasmania or the Coalition for Kids. So it has been handled extremely poorly, insensitively and in fact dangerously. And this amendment that we're dealing with here, which is the heart of the reforms, not only is this amendment reflective of the will of the House when it went through late last year, but it's an improvement, of course, on the language because it was drafted by the Office of Parliamentary Counsel, and we strongly support this amendment.
Thank you, Chair. God, how's that name? To repeat, it would certainly not be tabling the advice as requested. Make the point also that there were concerns raised directly by the Solicitor General in that briefing with members of the Legislative Council. And I'm advised that the Solicitor General's advice was based on the amendments brought forward by members in the other place as they were available at the time. There were 20 versions, and examples were cited by the Solicitor General independently as to his concerns. He indicated to the Legislative Council members at that open briefing that a fuller body of work was required. And in relation to the interest of the child, I was citing the views expressed by our Children's Commissioner.
Yes, who is actually supportive
Order.
of the intent of the legislation.
Order. Ms O'Connor, order.
But that element that I have referred to conveys a different impression, a different view.
Children supports these reforms.
And we will, as I've said earlier today, be getting further advice in relation to the laws that pass this place, as governments would typically do, and as I said, we will in this case. And I would just ask members, particularly those who've taken the opportunity today to unfairly besmirch the Attorney-General, who in my view has handled a very sensitive and complex matter of law in a considered and thoughtful way, to desist from that. She's not even in this place to defend herself today.
Ms O'Connor, order.
Chair, I'll just, unfortunately, I do not have in front of me some of those inflammatory, dishonest, divisive media statements that were issued by the Attorney-General. But they were certainly not sensitive. They were highly politicised and threw out there so many red herrings in order to create fear and confusion within the community about these reforms. And just responding to what the Premier has said about the Solicitor General briefing upper house members, yeah, sure. 8 of those members who attended that briefing took on board his concerns, and as experienced legislators, they backed these reforms.
Question is that the amendment be disagreed to. All those of that opinion say aye.
Aye.
The contrary, no.
No.
On the voices of the ayes have it.
Divide.
Division required. Ring the bells. No, you're right. Miss Dale, I'll call her next. Give you a spell. Give you a spell. I'll give you a spell. Whip's happy? Whip's happy? Stop the bells, lock the doors. The question is that the amendment be disagreed to. Ayes will pass to the right of the chair, the noes to the left. I'll appoint Mr Tucker, teller for the ayes, and Miss Dale, teller for the noes. Thank you. Results of the division. Ayes 10, noes 12. Therefore, the noes have it.
Amendment of the Legislative Council to Clause 22.
Premier.
Chair, I move that the amendment to Clause 22 be agreed to.
Question is the amendment be agreed to? All those that opinion say aye. Aye. To the contrary, no. The ayes have it.
Amendment of the Legislative Council to Clause 23.
Premier.
Thank you, Chair. I move that amendment to Clause 23 be not agreed to.
Member for Clark. Ms Haddad.
Thank you. I don't intend to speak for a long time on this clause, but I did want to give the Chamber the benefit of an example of what happens when you apply for a birth certificate in Tasmania, and to explain the intent of this clause. It's been all through this debate. Part of the scare campaign has been to explain, to say that it's going to be opt-in, opt-out, we're removing gender, all these kinds of ridiculous claims. How the Registrar of Births, Deaths and Marriages deals with these changes administratively will ultimately be a matter for her, but at the moment the way we've imagined that it may play out is that when you apply for a birth certificate, there would most likely be a box on that form where you apply for a certificate which would ask you, would you like the relevant gender marker as registered, because gender markers, gender and sex will be registered. Would you like that printed onto this form? So I just thought, a friend of mine's just had a baby recently, so I've got just a de-identified without the baby's details or the parents' example of the application for a birth certificate. And don't forget, Mr Chair, that this is actually the third step in what happens when a baby's born. First is the notification of birth that the hospital must do within 21 days. It's often done within hours. That will say the child's gender, male or female. Next comes the parents' responsibility to register the birth of the child. That has to happen within 60 days. And last of all, you can apply for a birth certificate. You don't need to, actually. I didn't get one until I was about 16 when I first went to apply for a passport. But if a parent chooses to apply for a birth certificate right there and then, or later on for their child at an older age, or indeed an adult applies, then there's a series of questions. You have to say who you are, who your parents are, where you live, where you want your birth certificate posted to, whether you want and here's the existing ticker boxes, Mr Chair, whether you want to be issued with a standard birth certificate, that's a box you can tick, or a standard and decorative birth certificate, that's a box you can tick, or a decorative birth certificate, Mr Chair, and that's another box you can tick. Then there's a subset of boxes, two lots of boxes. People are coping with this right now. Right now when babies are born, they're coping with this onerous task of ticking boxes on a form. The second layer of boxes is that if you have above chosen a decorative certificate, Mr Chair, you must then specify whether you would like that decorative certificate to include flora, pictures of flowers and leaves, a teddy, picture of a bear, or hands, pictures of children's hands. So they're the current options that you can apply for when you're getting a birth certificate issued for your child or for yourself. We would suggest that possibly another box would be added to that form just asking whether or not you would like to have the relevant gender marker as registered by the State of Tasmania also included in that form or not. Thanks.
Chair.
Ms O'Connor.
Yeah. Political correctness on that.
Chair, this is the clause that provides for application for a birth certificate, enables the registrar to issue a birth certificate that includes facts as recorded on the register. And I just wanted to take this opportunity, Chair, on this particular amendment to read into the Hansard the story of a truly impressive young man, George Kennedy, whose mum, Milena, is in the chamber watching today's debate. George is now 23 and transitioned at the age of 13 and wrote recently on Facebook, "Yesterday was Trans Day of Visibility and I'm torn with every year it passes. I see horrible things in the news and online about trans people, the treatment of us and the media's portrayal of us. It all breeds misinformation, fear and hatred. as the media and some of our politicians love to do to any marginalised group. Our own Prime Minister thinks it's, quote, ridiculous for birth certificate laws to change in order to accommodate trans people. George says, I was humiliated applying for a job I had to show my birth certificate for, which has my old name, and female written very noticeably. It's dehumanising to be treated like a freak, something that most trans people have almost certainly felt at some point. It's psychologically damaging, and I was suicidal for a long time, having no place in society and no hope for my future. Now that everything in my life is coming up Millhouse, it's easy to fade into the background and to pretend I'm a regular guy. I don't have to constantly answer questions about any surgeries or genitals or how I have sex, among other disgusting things you never ask a stranger, if you don't consider them to be below you. I don't have to constantly defend my identity when people with, quote, good intentions are just, quote, curious. It's a relief not to have to prove myself or strive for anyone's validation anymore. I'm well aware I've always had it easy compared to many of my trans brothers and sisters. And I'm often ashamed not to be more public, helping to normalise the trans community, because from what I've learned, people arguing on the internet, debating on TV or rallying for a cause rarely changes the opposing camp's mind or opens them to acceptance. It's meeting people one-on-one who've never met a trans person before, someone who has a media-fuelled fear or hatred of you, and just showing them you're a regular person too. I've been extremely surprised by some of the people who've accepted me, and by extension, trans people in general. I'm aware that saying this to an echo chamber of mostly progressive young people isn't making any profound changes, but this has been difficult to share, and maybe it's a good start. And George, you've just shared it more widely, and I was really proud to read your contribution into the Hansard. We strongly support this amendment, and just want to point out to the House that we are nearly done.
The question is that the amendment be sorry, Dr. Broad.
So throughout this long and torturous debate, there has been this myth in the community that birth certificates are somehow an infallible piece of identification that are absolutely free of flaws, and there is that if there's something wrong with them, then, you know, in a millennia's time, that error will be propagated and it'll be the end of all things good. So just to paraphrase, so during this debate, I went and had a look at my own birth certificate. So I got a birth certificate at some stage. I can't even remember what it was for, probably a passport or something like that. And I got out my birth certificate, and yeah, my birth certificate does say I'm male, so that's all well and good. But there's an error on it. There's an error on my birth certificate, and more than likely an error on my birth record. And that is that my father's birth date is incorrect. So the idea that birth certificates and indeed birth records are an infallible piece of information are not correct, because I stand here with a birth certificate that is demonstrably incorrect. It has my father's birth date, says he's born in 1944 and he was born in 1942. So these errors can be propagated. So the idea that a birth certificate is an infallible piece of information is flawed.
Sorry, Chair. On that, if we're doing full disclosure, Chair.
Ms O'Byrne.
In my post-baby haze, when I was filling out the form, I did manage to spell my husband's place of birth wrong, but it appears that Eleanor can still actually attend most public institutions, so I think it'll be okay.
The question is that the amendment be disagreed to. All those of that opinion say aye. Aye. To the contrary, no. No. The noes have it. Divide. Division required. Ring the bells. Thank you, Concert.
Thank you.
Whip's happy? Happy? Whip's happy? Whip's happy? Stop the bells, lock the doors. The question is that the amendment be disagreed to. The ayes will pass to the right of the floor, the noes to the left. I'll appoint Mr Tucker teller for the ayes and Ms Dow teller for the noes. Thank you. Thank you. Thank you. The results of the division, ayes 10, noes 12, therefore the noes have it.
Amendment of the Legislative Council to clause 24.
Thank you, Chair. I move that amendment to clause 24 be not agreed to.
Question is, Ms Dow. Miss Haddad, sorry.
Oh, Haddad. I do have some Irish heritage. We will be supporting the amendment as described coming back from the upper house. This changes one of the attempts of the lower house to have gender and sex recorded off the register, and it relates to the amendment discussed earlier, which will mean that the registrar will be required to record sex on the register.
The question is that the amendment be disagreed to. All those that opinion say aye. Aye. To the contrary, no. No. The noes have it. Aye. Division required. Ring the bells. Thank you. Whip's happy? Whip's happy? Lock the doors, stop the bells. The question is the amendment be disagreed to. The ayes will pass to the right of the chair, the noes to the left. Appoint Mr Tucker teller for the ayes and Ms Dow teller for the noes. Thank you. The results of the division: ayes 10, noes 12. Therefore, the noes have it.
First Amendment of the Legislative Council to Clause 32.
Premier.
Thank you, Chair. I move that the First Amendment to Clause 32 be agreed to.
Question is that the amendment be agreed to. All those that opinion say aye. Aye. To the contrary, no. The ayes have it.
Second Amendment of the Legislative Council to Clause 32.
Premier.
Chair, I move that the Second Amendment to Clause 32 be agreed to.
Question is that the amendment be agreed to. All those that opinion say aye. Aye. The contrary, no. The ayes have it.
Third Amendment of the Legislative Council to Clause 32.
Premier.
Thank you, Chair. I move that the Third Amendment to Clause 32 be agreed to.
Question is that the clause as read, that the amendment, be agreed to. All those that opinion say aye. Aye. The contrary, no. The ayes have it.
Amendment of the Legislative Council to insert new Clause A.
Premier.
Chair, I move that the amendment to insert new Clause A be agreed to.
The question is that the amendment be agreed to. All those that opinion say aye. Aye. To the contrary, no. The ayes have it.
Amendment of the Legislative Council to insert new Clause B.
Premier.
Thank you, Chair. I move that amendment to new Clause B be not agreed to.
Honourable Member for Clark, Mr. Dad. Not agreed to. Question is.
Ask the question, sorry.
Well, the question is that it be disagreed, that the amendment be disagreed to.
Those of that opinion.
Right. So the question, the question is that the amendment be disagreed to. All those that opinion say aye. Aye. To the contrary, say no. No. The noes have it.
Aye.
Division required. Whip's happy? Whip's happy? Yes. Lock the doors, stop the bells. The question is that the amendment be disagreed to. The ayes will pass to the right of the chair, the noes to the left. I'll appoint Mr Tucker teller for the ayes and Miss Houston teller for the noes. No, sorry.
Thank you.
Thank you. Thank you. The results of the division, ayes 10, noes 12, therefore the noes have it.
Amendment of the Legislative Council to insert new clause C.
Premier.
Thank you, Chair. I move that amendment to new clause C be not agreed to.
Question is that the amendment be disagreed to. All those that opinion say aye. Aye. The contrary, no. Aye. The noes have it.
Aye.
Division required. Order. To get a new pad down there soon, surely.
I'm sure Barry's left us some good
Hit the
stock.
photocopy.
Yeah.
Whip's happy? Whip's happy? There is no. Oh, no? Oh, no. Okay. Happy? Happy and happy. Stop the bells, lock the doors. The question is, does the amendment be disagreed to? Those of that opinion, the ayes will pass to the right of the chair, the noes to the left. I'll appoint Mr Tucker teller for the ayes and Ms Houston teller for the noes. The results of the division, ayes 10, noes 12, therefore the noes have it.
Amendment of the Legislative Council to insert new clause D.
Premier.
Thank you, Chair. I move that amendment to new clause D be not agreed to.
Honourable Member Clark. Mr Dad.
Thank you, Chair. I wanted to put on the record some of the details of this amendment and just make some final remarks, recognising that we're not far from the end of these amendments. This clause actually creates an offence in the Birth, Deaths and Marriages Act. The reason I wanted to speak on this is that it creates an offence relating to some of the unease that was felt in the community about these changes, and some of that unease, which was, as I said earlier, fuelled into quite a widespread hate campaign and scare campaign. It creates an offence for if you attempt to use a birth certificate that doesn't reflect the right information. So in other words, a fraud type offence. There are already offences on the books that would have covered this kind of thing. But the reason that the Upper House saw fit to include an offence provision, I think, was driven by the fact that there was that level of scare campaign being run in the community. And that radio interview that I referenced earlier covered this topic as well, about using wrong birth certificates or changing genders on birth certificates multiple times. And the question that was given to the Leader of Government Business was whether there was any clarification that she'd been given in the legislation that would limit the number of times a person is able to alter their gender in a defined period of time. How many times could you do it? Could you do it every day, he asked. Very clearly, as I said earlier, the answer to that should have been no. It would not be possible to do that every day, but she answered, at the minute there's nothing in the legislation to say how many times you could or you couldn't. Well, either she was misinformed or she was just malicious, Chair, to say that on the radio. Not only is that not something that could happen under these changes, but there's indeed even an offence provision created that relates to it in one way or another. We did hear horrible hate campaigns that were encouraged and fuelled by members of the government and others, that public toilets wouldn't be safe places anymore, that women's shelters and women's legal services and women's health services wouldn't be female-only places anymore, that we'd erase gender, that sporting organisations wouldn't be able to cope with these changes, indeed that we'd legalise male pregnancy, which is quite farcical. All of these were rebutted. They were rebutted by people who understand these changes, and they were rebutted by the organisations that were criticised. And in the middle of the lower house debate last year, there was a joint press release issued by Women's Health Tasmania, Hobart Women's Shelter in Gender Equality, which is a domestic violence service, and Women's Legal Service Tasmania, who explained that they already service the needs of transgender women and indeed recognise that transgender women are women, Mr Chair. And those services are women-only spaces, and that includes transgender women. But this misnomer that transgender people are out there to trick people, which is offensive and deeply offensive and should be offensive to everybody in this chamber, was allowed to fester, and it was allowed to grow wings in ways that the government assisted along the way, indeed pulled out all stops to encourage them and did nothing to dampen those fears. So the changes that we've seen today pass in this chamber. I think the government's proved its point. We've divided on every clause. I'm sure we'll divide on these two remaining clauses, Mr Chair. So the government's got their tallies. I'm sure the press releases are already drafted and ready to be emailed out to the media right now to explain how Parliament has been hijacked once again by opposition parties, to explain that what the Upper House did was unparliamentary, unconstitutional. That's how it was described by some of those members upstairs last week, that it was a flawed process, that it was unparliamentary. The Parliament had never seen something like this before, like this process before. Now, I might be new to this place, but I thought a chamber of a parliament amending a bill and sending those amendments for consideration by the other chamber, that chamber making further amendments to be reconsidered here, surely that's actually at the heart of parliamentary democracy. Sure. That's what making laws is about. The fact that the government doesn't have the numbers to ensure that any changes that get made to legislation are the changes they want, that's not an issue with parliamentary democracy, Mr Chair. That's an issue with this government. And this government has given time and time again commitments to transgender people in Tasmania, commitments to the lesbian, gay, transgender, intersex and gender diverse communities, that they have their interests in mind. That's been done through government policies in education, in health, in justice, written policies, documents that exist out there about how the rights of transgender and gender diverse people should be respected and how those people should expect to be treated by their public institutions. And I commend the government for those policies. We support them and agree that people who are transgender or gender diverse should be treated with respect and should be expected to be treated under the principles that are outlined in those policies. But what are those people to feel today when they see every government member speaking out through divisions on the floor of the House? It may have proved the point that the government wanted to prove, but it's proving mine too. How can those people feel that those principles that the government seeks to stand behind in those other policy documents across departments have any weight and mean anything to those people? Those people have been given assurances by the Premier, by the Attorney, by heads of agencies that transgender and gender diverse people matter, that they are cared about, that they are recognised as existing in the gender that they are, and yet at this opportunity, for political reasons, we see every clause divided on and opposed, and it's not right. So either I'm wrong, and the Premier, I invite you to tell me why I'm wrong. I'm wrong that the government cares about transgender and gender diverse people. I'm wrong that the government has those policies in place across government about how those people are to be treated and treated with respect and free of discrimination. Or alternatively, I'm right that the government feels that way, and it's an utter anomaly to have so publicly gone against those principles by opposing every part of this change. So the Premier's right to say this is the Attorney's bill, and my condolences are absolutely with the Attorney and with her family. I haven't brought her into disrepute in this place today, but your words have weight, Premier, through you, Chair. Your words matter. You're the leader of this government, you're the leader of this state. I respect the office of the Premier of Tasmania, and your words matter to the transgender and gender diverse community. And I would invite you in these final moments of this debate to put aside those scare campaigns that we've seen over the last several months, weeks and days of debate in the chamber and elsewhere, and tell me that I'm wrong, that those things matter to Tasmanians. Because at their simplest description, these laws just do a few simple things. Remove the forced divorce provision, which we're required to do under Commonwealth legislation, remove the forced surgery provisions, and change the existing process of how to have a gender marker changed on a birth certificate from the existing processes to a new, simpler administrative process involving a statutory declaration. So that's it at its core. I just wanted to read something quickly that I hope can be followed up tomorrow, but it's a letter that appeared in today's Mercury from Charlie Burton of Sandy Bay. And Charlie said, I thank and congratulate Upper House members who voted in favour of legislation to give trans and gender diverse Tasmanians equality and protection before the law. Thank them because this legislation will make a real difference to our lives, and congratulate them because many members kept an open mind, were willing to hear personal stories of those affected, and did not allow themselves to be swayed by the misinformation and outright lies being spread by opponents of the reforms. This legislation must be among the most scrutinised in the state's history, having been the subject of days of debate by the Upper House in a previous form and the Lower House. Tasmanians have nothing to fear from these reforms. Once passed, it is unlikely anyone other than trans and gender diverse Tasmanians will even notice. I urge members of the Lower House to be true to the will of the Parliament and pass this legislation. It's my sincere hope that Charlie will be able to write a follow-up letter, Mr Chair, congratulating members of the Lower House for respecting the will of the Parliament and passing these changes into law, because Charlie is quite right when they say no one will notice the effects of these changes except for the people who need these changes most, which is transgender and gender diverse people. It won't affect anyone else in the community except for those people who need them most. So I'm proud to be part of a Labor Party that has always and will always stand up for the rights of LGBT people. And these changes represented today will simply protect further the rights of people who need it, while not infringing upon or diminishing the rights of anyone else in our community.
The question is that the amendment be disagreed to. All those that opinion say aye. Aye. Contrary, no. No. The noes have it. No. Division required. Ring the bells. Whips happy? Yep. Happy. Stop the bells, lock the doors. The question is that the amendment be disagreed to. Ayes will pass to the right of the chair, the noes to the left. I'll appoint Mr Tucker teller for the ayes and Dr Broad teller for the noes.
Thank you.
Thank you very much.
Thank you.
Thank you. The result of the division, ayes 10, noes 12, therefore the noes have it.
Amendment of the Legislative Council to insert new clause E.
Premier.
Chair, I move the amendment to insert new clause E be not agreed to.
The question is that the amendment be disagreed to. All those that opinion say aye. Aye. To the contrary, no. Aye. The noes have it. Aye. Division required. Ring the bells. Thank you. Whip's happy. Whip's happy. Happy? Stop the bells, lock the doors. The question is that the amendment be disagreed to. Ayes will pass to the right of the chair, the noes to the left. I'll appoint Mr Tucker, teller for the ayes, and Mr O'Byrne, teller for the noes. Straight away. Thank you. The results of the division, ayes 10, noes 12, therefore the noes have it. The question is that I do report a certain resolution. All those of that opinion say aye. Aye. To the contrary, no. The ayes have it. Speakers. The speaker's here. The Speaker has the honour to report a certain resolution.
Thank you. The question is that the resolution be agreed to. All of the same opinion say aye. Aye. Those to the contrary, no. Aye. I think the ayes have it. The ayes have it.